On Thursday, a panel of 5 Constitutional Court judges dismissed an application by four-time presidential candidate Dr. Kiiza Besigye asking court to nullify the offence of unlawful assembly in the Penal Code Act. The justices, led by Kenneth Kakuru, said although Besigye's petition raised issues of constitutional interpretation, they would not grant him remedies, saying he should seek audience before his own court or before the judge who swore him in as president.
I would therefore decline to grant him the remedies he seeks in this petition. Maybe he will have to seek audience before his own court or before the judge who swore him in as president.
On May 11, 2016, Besigye secretly swore himself in as president of Uganda, a day before the official swearing-in ceremony of President Yoweri Museveni. The obiter dictum, as it referred to in law, has come under criticism, especially among opposition, saying the statements were uncalled for and biased.
Maybe they wanted to demonstrate judicial humor, but if that was the case, then they took it too far. It was a rude joke, because we are talking about serious matters touching constitutionalism in this country.
These judges have not only betrayed the judiciary, but they have betrayed the whole legal fraternity. That you say, Besigye, you can't come to court because you declared yourself a government and you were sworn in, you go to the judges. Really, it was shocking.
Good morning, stop them!
They claim that Besigye is a Ugandan who was seeking nothing but justice in courts because of the continued abuse of his personal rights.
You can't deny Dr. Besigye justice because he saw in himself. You can't deny him justice because over that, over a political activity. The Constitution is clear, Article 126, Sub-Article 2E, that substantive justice shall always be administered without undue regard to technicalities.
They are supposed to decide the matters impartially. They are not supposed to show anger, to show that they are very bitter with somebody.
Because this statement should have come from Mwesigwa Rukutana, the Attorney General, and Byarahanga. It should never have come from the bench, from the judiciary. Because the moment you get the judiciary to begin doing politics, we will not be motivated to go to them anymore.
Some have described the ruling as partisan, and they are planning a move to appeal the decision in the Supreme Court.
Vigorously, we are going to indeed pursue it and challenge this decision.
Now, the president of Uganda Law Society says the justices were right in their decision.
Yes, and it's within his right, because it's not in law we say it's not the holding. In every case, you have what we call the issues and the holding. The holding is very important because the holding sets the decision of court. The obiter is important in as far as it cautions the public but does not set the decision of court.
On advising Besigye to seek audience in courts of the judge who swore him in as president, Simon Peter Chinobe says in law judges have a right to give opinion on any matter in court.
See, that's why we call it obiter dictum. The obiter of a judge can touch any matter in society concerning either the case before him or otherwise.
Chinobe warns politicians on their continued politicization of matters of court.
To be allied to the fact that every battle has a winner and a loser, and when you lose, take it gracefully and go on to the next step. But do not disrespect the courts of law, do not harangue the courts of law, even when you don't agree with their ruling.
In their ruling, the justices said Besigye, by swearing himself in as president, appointing a cabinet and the National Assembly after the judgment and orders of the Supreme Court had been passed in the Amama Mbabazi versus Yoweri Kaguta Museveni election petition, was and still in contempt of court. Dr. Kiiza Besigye has not yet come out with any statement on the Thursday ruling. Ivan Chimutigozi.